What I wanted to do, Will, was talk about 17th century history, which we've been going back and forth for a while on this kind of stuff. And I
Yeah,
think it's relevant to what's going on now. I think we're in
yeah,
a vicious cycle of behavior, and it's on repeat. We keep coming across the same types of issues. So
yep,
these presentations are just to look at the older history and what was going on with the legal system, the political system, and all that kind of stuff, and see where it kind of is relevant to what we're experiencing now.
I think very few people seem to have looked at history in the context of how is the law being adhered to, constitutional law having been the context, and understanding the events that unfold in that context. I don't think many have done it. So this could be, I think, really interesting.
I think you're right, because a lot of historians, they kind of report on the facts, but they don't actually look at any sort of, they don't take a moral stance.
Yeah. It might be worth just putting a little background to the viewers here. So we're talking about James I here. James I was the first of the Stuart kings of England, and he was already king of James VI, isn't it, of Scotland, and had been from 1567. And so he become king of England from 1603. So this is right at the beginning of his reign, and he reigned until 1625. So yeah, just a little bit of a framework, and he followed Elizabeth I, who was is that right? Yeah, that's right, isn't it? Who was the last Tudor king.
Yes.
So we're just at the entry point of this interesting phase of history that you and I have been sort of looking at.
It's worth mentioning, like the beginning, when James took the throne, there was quite a few things that happened, like plots to try and kill the king, remove the king. There was even a plot to kind of kidnap him. I don't know where that was going to lead. So you had the by plot, I think, the main plot, and then you had the gunpowder plot. So you had Guy Fawkes, the main gunpowder plot. But then two plots before, I'm pretty sure, if I remember right, were to do with trying to remove the king. It wasn't so much as severe as trying to kill the king. I think that involved, is it Sir Walter Raleigh or Raleigh?
Yeah, Raleigh, yeah.
And he ended up getting convicted. He spent a lot of time in jail. I think he was released on a pardon to do some sort of expedition, but it failed. And he was his murder charge, his execution charge was reinstated, and he was beheaded. So didn't really end well for him.
A bit of a gruesome time.
Yeah, it is.
Okay, interesting. Yeah.
Should we get into it?
Yeah, absolutely.
Richard Bancroft was the Archbishop of Canterbury between 1604 and 1610. Richard Bancroft was head of the church with significant control over the Court of High Commission, the ecclesiastical court, When a dispute relating to land arose between the Archbishop of Canterbury, Richard Bancroft, and another party, Bancroft approached James I for judgment and resolution, which was the royal court. James adjudicated the case and passed sentence in Bancroft's favour. The main issue with this was whether or not James, who overlooked the King's Court in the upper house of Parliament, had the legal right to make formal judgment on any case. It was viewed by many as a significant overreach of authority and jurisdiction.
Yeah. Yeah, interesting. So this is very much the character of the kings of the time around this point, and getting considerably worse through the century that was to follow, I would argue.
I think because he also was part of the Court of High Commission, he probably had heavy influence over that as well, which was a prerogative court.
Yes.
So this is the case of Prohibitions 1607, which obviously the previous slide kind of it leads into this. So the case of Prohibitions was a landmark decision made by Edward Cook, who was Chief Justice at the Court of Common Pleas. It quickly came to a head when it was brought to the attention of the court that James had adjudicated a land dispute himself at the request of Richard Bancroft, who was obviously the Archbishop of Canterbury at the time. Bancroft argued that the king had clear authority to decide cases of law by the word of God in the scriptures. Cook intervened, arguing that King James I was subject to the law and had no authority or jurisdiction to adjudge any case. He continued to state for the record that what the king had attempted to do was the job for a court of justice according to the laws and customs of England. I would think that that was lord of the land, common law, trial by jury.
Yeah.
It was held that the king could not rule on any case before him. The king is under no man, yet he is under God and the law.
Yes.
So
yes.
It's quite interesting that when it was taken to the Court of Common Pleas, that was the outcome.
Yeah.
So there was kind of courts that did, you couldn't kind of fudge them, you know, they had to adhere to the law in that sense.
It was an interesting time. We're already building the picture here, aren't we? That of the sort of sense of the divine right of kings, very different from perhaps some points in our English history at earlier times when the king was very much aware and had that humility that they were under the law themselves, that they were at the first among equals. We're not in that kind of understanding here in this situation at all. The monarchy had taken on this view of itself that it can do what it likes, essentially.
How do you think that happened? How did we go from like Middle Ages, medieval, like 1215, where that understanding was there and we had the Great Charter and, you know, we had them checks and balances to this?
Yes, I mean, I always think of it sort of incremental, certainly, but actually in reality it would be up and down, because there would have been better times, there would have been worse times. But in general, I would say that even by 1215, obviously things were going wrong because there was the need for the whole Runnymede event anyway at Magna Carta. The very fact that was a required thing, and it took the insight and intelligence of the Archbishop Stephen Langton at the time to probably explain, I suspect, to the barons and give them the context of how this was actually supposed to work. Stephen Langton actually did understand natural justice, the idea that the people's rights come from nature. It's something that is self-evident, if you like. So that language that we see in the Declaration, much later, Declaration of Independence in behind the American Constitution, that sort of inevitability that actually there's a self-evidence to the fact that people are born with natural rights. Stephen Langton in 1215 understood that himself, which is very interesting, and that he would have helped the barons come to understand that and have clarity over that, I would think. And so even in 1215, it needed that insight to bring that situation about. It was a dangerous time. So things had already started to go off the rails. And so when in particular, probably the Norman kings generally, there's a bit of a kind of an impulse from the Norman sense of how things should happen, which is centralization and control, very much. Unlike, I would say, the sort of more municipal governance or sense of how things should be governed from the Anglo-Saxon tradition that went before, which was a much more humbling. I'm not saying that they were all perfect all of the time, of course not, you know. But we hear about Edward the Confessor's laws of England. You know, he was the last king apart from Harold, who was killed at the Battle of Hastings. The one just before was Edward the Confessor, who was revered for the laws of England, and that was a time of much more understanding of the fact that the people are the final arbiter of law. That they're much keener to, if you like, to elevate that sense of justice coming from the people themselves, whereas the Normans, I think, didn't find that easy to uphold that sense, and it was all much more about centralized control. And so by this point, much later, you know, things had gone pretty awry by that point. So yeah, that's my take on it anyway, certainly.
When the Normans invaded, that they started to usurp the system in a sense, like override old Saxon
Yes.
laws.
Whittling away of the court system already quite early on by that stage, even by the sort of 1300s, as we were getting into the late 1200s. Edward III, I think, was having a bit of an attack on the way the courts were working, and remember, it was incremental. So this was pretty small changes, so that people wouldn't really have been recognizing, and of course they would have been seen as sort of, you know, probably fairly reasonable at the time because of practical decisions, pragmatic decisions being made because of, you know, whatever. And we could go into that at a later stage, but yeah, there was sort of gradual incremental changes that were bringing about a centralized form of control. And certainly around that time, 1300s, things were not going, you know, we're going in the wrong direction, but it wasn't that bad at that stage. There was still a sense that the kings had to tip their hat, if you like, to the sense of the 1215 Magna Carta. That was probably the way things were going, I would say.
Even common law had started to be distorted, because if I remember right, some of the books that I've been reading, that like case law and all that kind of stuff started to emerge.
Yes, the introduction of case law. And I can't remember, and you're probably ahead of me on that, but that was another Norman influence, certainly. And case law itself, as a body of law, is not necessarily a problem, but the key to it shouldn't be considered as law. It can be considered a body of wisdom to affect future cases, but the key to it is that it shouldn't bind a future jury. Yeah, always down to the consciences of the jury. So it shouldn't bind the decision of the jury, but it should infuse that, maybe, because there's a lot of wisdom in case law, certainly.
So this was an actual Puritan barrister of the time, Nicholas Fuller, and this was another case. This was more about, this guy was kind of challenging the prerogative courts, how they were operating.
Yeah.
So we represented a lot of people, like fighting the Court of High Commission,
Yes.
the Star Chamber, like unlawful fines and unlawful imprisonment. So Nicholas Fuller was a Puritan barrister who challenged the corrupt proceedings of prerogative courts, such as the Court of High Commission and the Star Chamber. He had clients that had been falsely imprisoned or heavily fined by the Courts of High Commission, which were ecclesiastical religious courts that dealt with religious dissenters and nonconformity. Fuller took this case to the Court of Common Pleas, and it was heard by Chief Justice Edward Cook. Fuller argued that common law courts had the power to free ecclesiastical prisoners if cases involved temporal matters. Edward Cook agreed that common law courts had authority to intervene if the Court of High Commission involved itself in temporal matters and ruled in favour of Fuller. This ruling was largely ignored, and Fuller was unlawfully charged with heresy, schism by the Court of High Commission and sent to Fleet Prison. Rulings at the time were difficult to enforce against prerogative powers and powers of the church. Going against the monarchy and the church had its consequences.
Which actually shows the bravery of people sticking their neck out at the time. Interesting.
What I find interesting about that, Will, is even when it goes through a legit course, a legit hearing, that nobody actually took any notice or abided by it.
Yeah.
The people who actually were seen as a threat to that prerogative and the church and so on were actually punished.
Yes.
It's kind of ironic, isn't it, that these people were actually trying to look for some sort of justice in a system and end up being locked up themselves.
Absolutely. And I suppose you could say that the problems back then at this time were similar to now, but different at the same time, in that at least some courts knew how they were supposed to be operating. And yes, and you had one or two key people, at least within the system, who actually knew how it was supposed to operate, had a sense of constitutional law. But worryingly, yes, exactly, the prerogative power of an authoritarian state right from the top dealt with those people who were trying to operate correctly. Pretty worrying time, probably pretty scary, I should think, to be those people, those heroes who were actually standing up for truth and justice.
I think what else is interesting is how these courts kind of overlapped into different jurisdictions that they shouldn't really have been involved in.
Yeah.
Like the key thing to this case was like obviously the Court of High Commission was an ecclesiastical court. It dealt with religious matters. But they kind of overstepped that mark, imposing fines, taking people's private property and punishing them in that way, which was seen as more of that should have been dealt with in a common law court with jury. You know, so we're going back to the whole Article 39. You know, people shouldn't be losing their property or being imprisoned without a jury of their peers.
Absolutely. Yeah. So you've got power games going on. You can see how that was happening, just in as you do in any age, and the same now, of course. But yeah, interesting.
We were talking about obviously the divine right of kings approach to governing, and obviously these kind of cases arose. For maybe a small period of time, the king had been checked and maybe fell into place a little bit. But it could be argued that these kind of courts, he was just replacing his, like, imposing his kind of will by having, the Lord Chancellor of these courts. It might have been the Star Chamber, the Court of Chancery, the Court of High Commission, and these people were all in support of the prerogative power. So they were still able to enforce whatever they wanted to do through these people.
Yes, I mean it's worth just clarifying here, because there's confusion, because the monarch, the head of state, does have prerogative power.
Yeah.
But the key to that is that it must be lawfully exercised. So the prerogative power is most definitely there, and right that it should, because it's the king's government. So the administrative government falls under the authority ultimately of that first among equals, the head of state. And if that head of state is operating within law himself, then those prerogative powers are meant to be there for the protection of the people, Right.
Yes.
So how should all of this operate? Well, really, everything should be becoming before a trial by jury, as you've said. And then, of course, the authority of the king in that situation would be the Court of Appeal. So, because you've got to have an appeal system, if your community sort of takes against you, and you've been set up in some way or whatever it is, and there genuinely is, a problem with the local jury kind of like finding against you when in fact actually that might be seen to be a problem in justice. Then you've got to have a court of appeal, and that's what the king was there for, was to have those courts. But all they have the power to do is if that's an unsafe conviction, it would be a case of sending that back, just as it does now, to send that back to another trial by jury. And that's really all the power that is meant to be there. And if the king is operating outside that and just arbitrarily, deciding laws without that whole process of trial by jury in place first, and it's not a proper dealing with an appeal, then clearly the king himself is stepping outside the law, and then that's where a Runnymede type event, like happened in 1215, should be occurring, which is to bring the king to a trial by jury of his own. And this is the bit that was not really understood properly. All through history, we've got this problem of not really understanding how this is supposed to happen. And so as we're beginning to see, well, we'll see it a little bit later, is what do they think the remedy is for an out-of-control king? What is that? What should that be? Well, what that becomes is we're setting the stage, I suppose, for what they think that remedy should be, and we'll pause at that point, and because that's a theme that's going to come up more and more, isn't it, as we go through this.
So this was Dr. Bonhams Case 1610. In the case of Dr. Thomas Bonham versus the College of Physicians in 1610, who were recipients of unfair patronage by the monarch, Cook upheld the jury's verdict, ruling that the common law was supreme to overrule the statutes of Parliament and monarch. And this is what the judgment was. The common law will control acts of Parliament and sometimes adjudge them to be utterly void. For when an act of Parliament is against common right or reason, or repugnant or impossible to be performed, the common law will control it and adjudge such act to be void. So that was Chief Justice Edward Cook.
Good man.
So that's a brilliant judgment, that.
Totally, yeah. Cook got it. It's funny because you were hinting, weren't you, earlier already, that Cook didn't quite get everything, and he wasn't quite this full picture, but he totally got this. He was pretty much there, actually, in this, definitely.
And this is what started to get him into trouble, to be fair, because he got a lot of attention after this ruling. But it's interesting to see here that the common law will control acts of Parliament. So it's already hinting at a common law trial by jury can annul legislation in a particular case.
And as a quick reminder for the viewers, it couldn't operate any other way. It has to be like that logically for the entire Constitution to function. Otherwise, you've immediately got arbitrary authority coming into play, as Lysander Spooner said later. If you want the people to be their own government, if they are the people governing themselves, which of course means that you're upholding individual rights, if that's the concept that you want to align yourself with, which is of course the natural concept, then that means that the authority of the people, they are the final arbiter of law through the mechanism of trial by jury, must be the case. That means in turn, logically, that any kind of legislation that is created from Parliament must be sit below the authority of the common law, which is in effect the decisions of trial by jury and the customs of the people. It has to operate like that logically. Otherwise, you're also automatically laying the foundations and the seeds for a tyrannical government, ultimately. Can't possibly operate any other way. So, yeah.
And we've got quite a few checks, Will, haven't we, before it actually gets to trial by jury? So we like in the case of legislation, it goes from the lower house to the upper house to the king or queen, doesn't it? So you've
Yes.
got them three checks as well. It's not really meant to go any further if it is.
No.
If it is breaching
It's
constitutional law.
absolutely correct. And so you've got a lot of checks there. And if they're operating and not being denied, as what began to happen, of course, that was the whole point, because they misunderstood how it was supposed to operate. And the other thing actually that's worth saying is that of course the monarch ultimately, under an authentic constitution operating correctly, would always have had the right to repeal or amend any legislation, because he was ultimately responsible for any legislation on the statute books that might have been offensive, if you like, to the rights of the people. So if he needed to repeal or amend any legislation that was clearly in breach of the common law constitution, then he would have had the right, ultimately the right, to do that as head of state, and rightly so. Now, that doesn't mean to say that he has the right just to do anything willy-nilly and just decide, I don't like that piece of legislation because, whatever. No, you can't do that. And of course, that's why the ultimate sanction on the king, of course, must be trial by jury. It's why his peers, the barons, must be ready to step in and act as his peers at any point. You're not really setting up, we're already hinting at this, we are not really setting up Parliament as the counterbalance for the king. It is a counterbalance in a sense, but it's not supposed to be the ultimate sort of pendulum swing, as what started to happen was too much power of the king, out of control, swinging towards Parliament, also becoming too powerful as well. Otherwise, you create one monster, and then you create the next monster. So ultimately, it wasn't supposed to be like that. Your check, ultimately, is that all parties, Parliament included, are behaving correctly under the law. Yeah, and that's ultimately the responsibility of the monarch.
And I suppose that's where some of the contradictions come in for me.
Yes.
With people like Cook, even, who's kind of hinting at like Parliament should have more powers. There should be a bigger check there for Parliament. It's not actually going on about where the people come in.
Yeah.
And they're kind of forgotten, aren't they, with this pendulum swing between monarchy and Parliament. Even when he was fighting for the independence of the courts, it wasn't really independent. He didn't take it that step further. He didn't carry it on to trial by jury and jury independence. It was more so like case law was the final arbiter.
Yes, which is also dangerous as well, as we've said. Yeah, no, you're absolutely right. So we're beginning to show that you had good people here, like Chief Justice Edward Coke, pronounced Cook, of course, as we've said, not Coke. But he got it, and mostly, but he didn't quite understand the whole thing, the whole picture, and that was the problem with many, I think.
And because they were few and far between as well, these kind of people, because not many people had the courage to challenge these impositions. There isn't that many people, and I've read quite a lot. There is even people who were just lawyers that's seeing what was going on, and seeing the problems of how this system was operating.
Sure.
But obviously, the people didn't want to end up in prison or worse, so
there was definitely the real serious threat of fear.
Okay.
And of course, in those days, you'd be run through. It was quite an unpleasant time to be, you wouldn't just be fined or just, possibility of put in prison. It was, it was nasty. You could end up on the gallows or whatever.
Oh yeah, 100%. Because I don't even think this is how ironic it is. Even when you were speaking out, you were just put in prison. There wasn't any trial.
Yes.
There wasn't
Yeah.
any sort of fair hearing. It was just like, you're guilty of this and you're going to jail. That's the end of it. Just get
Yeah.
rid of you. Get rid of that voice, that threat.
Absolutely.
So this is an interesting one, Will. The case
Yeah.
of Proclamations, 1610. So James I was issuing proclamations which attempted to amend existing laws, including common law, going as far as to create new offences at his own pleasure and without Parliament's approval. Chief Justice Edward Coke ruled that the king could not extend his prerogative to create new offences or change the common law by proclamation, pointing out the clear constitutional limitations placed over him by the Lord of the land. This case was only reinstating notions that already existed. No man is above the law, not even the king, and all are equal under the law. James I just had to be reminded that his prerogative could not override constitutional law. This was also a clear message to prerogative courts such as the Star Chamber and enforcing proclamation. Interesting.
Yes, interesting. I'm not. I might just attenuate this slightly. I mean, so this idea that the king, as the head of state, most ultimately responsible for statutory governance through the legislature.
Yeah.
If the king was a pious and fine leader, and wanted to introduce a statute to uphold or bolster the constitutional principles, does he have the right to do that? I would say ultimately,
Yes.
absolutely. So we've got to be clear that ultimately the head of state, if he's operating within the law, he absolutely does have that right, and that changes things a bit. People often so was Cook right? Yes, kind of, but not entirely. You've got to reserve the right of the head of state ultimately, that if he's operating within the law, then yes, it is absolutely his right, as the kings did before the formation of Parliament, which was an advisory council ultimately, wasn't it? Originally, yes, the king ultimately is the government, because the king is a representation of all sovereigns. Yeah, he is the sovereign, the sovereign that is at the top of the government, if you like, as opposed to you, Damien, as another sovereign and me as another sovereign. He is the sovereign that's been chosen to and kind of elected, essentially, even though we're talking kings and queens here. It is meant to be a kind of election, essentially. He is the head of state, the first among equals, the sovereign that represents us, if you like, as at the top of the administration, and therefore is able to enact his sovereignty to bring about legislative principles that are in alignment with the law. So I would say actually that is the case, but I get the sense of what Cook was saying here. Absolutely.
I think it came about because for me, it's another case of the waters have been muddied and the confusion, and also because the kings of the time were abusing their authority or or overstepping their own jurisdictions.
Absolutely.
I think that's what it is.
Already.
I mean, it again comes back to the steps weren't taken
early enough. Yes.
They weren't taken further enough in a sense. It wasn't explained that the king is actually responsible to do that. And as long as he is within the framework of the law and he isn't abusing his powers, then he should be perfectly okay to do that stuff.
Right.
If it's in line with the rule of law.
Absolutely. It means that the governing system remains legitimate. Yeah, and that's the key. As soon as they delegitimize themselves by acting outside the law, then that's the problem. That's where that has to step in. That trial by jury, that check ultimately has to come in. But the ultimate responsibility for that is the head of state. Is the most.
It was always the approach is how do we limit the king? I think was a problem as well.
Right. Yes,
trying to kneecap him. you know, and take away all his duties and, you know,
Yeah.
what he was responsible to do for the people, not for himself.
Yeah,
You know?
exactly. And as I said to you before, you can't very well expect a king who's taking on the position of monarchy to govern according to laws and customs, and to do the things like that he should be doing, like upholding the rights and freedoms of the people through through upholding trial by jury as a mechanism. You can't expect him to do all of that if he doesn't also have powers. Yeah. You can't say, yeah, it's your responsibility to do all of this, but actually we're not allowing you, on the other hand, to do various things that actually he's supposed to be able to do. It doesn't make sense. So this sort of, I mean, that's what we have right now, is this sort of gaslighting about, well, does the king actually have prerogative powers? And well, yeah, he's meant to have those powers. Well, he does really, but actually he wouldn't. It's this kind of like fudging the issue that's going on. You can't expect him to govern unless he has the powers to do it. It's a complete contradiction,
Yeah, it's definitely like that today, surrounding the prerogative for royal assent.
Yes.
It's kind of like, yeah, he can do that, but he won't.
Yeah.
He won't do it. So it's kind of like, well, no, he's responsible. He should be doing that. He should be check on that legislation that's coming up to him.
Yes, and that's also a translation, of course, in this or a mistranslation of that goes into this business of not taking part in politics. Oh, we don't want the king to take part in politics. That's not true, actually.
No.
It depends on how. Yeah, absolutely the king is supposed to get political if the political machinery beneath him is starting to encroach on the basic freedoms of the people. And starting to breach the Constitution. Yeah, if you call that political, then he bloody well is supposed to get political. So, yeah, that's kind of another flavor of it, isn't it, really, in a way?
It's almost like the Privy Council and his advisors are kind of that branch of government is taken over that kind of stuff.
Yeah. I've got another quotation here that's quite interesting from Cook himself, actually. So he said, if Magna Carta was for the most part declaratory of the principal grounds of the fundamental laws of England, they, Magna Carta and Carta de Foresta, were for the most part but declarations of the ancient common laws of England, to the observation and keeping whereof the king, the government, was bound and sworn. So that gives you a bit more of a flavour of what he was basically saying, and he was right about that. He just didn't take it quite to the furthest extent of really understanding how that was supposed to operate, but it was good.
I suppose the Magna Carta itself didn't take it to that either, did it? Because that's kind of, with the whole trial by jury thing and the jury independence, it's not clear cut in a sense of how it's explained.
Yeah, I mean, I think there were parts of Magna Carta that should have explained it more clearly, certainly, and parts of Magna Carta was brilliantly written, and parts of it were not. I mean, everyone goes on about Article 61, but as a piece of writing, it was an absolute disaster.
Yeah,
not very clear, but yeah.
But that quotation, what you've just read out, Will, that's pretty clear.
Yes, that is actually. I mean, he was pretty clear, but he just didn't translate that, I think, into this concept of holding the king to account through trial by jury as the ultimate thing, But he's good. He's come out with some really good stuff. He's a good man generally. I've, on the whole, given sort of 9 out of 10, maybe at the moment.
Yeah, definitely. I think he was one of the few that was trying to reverse the kind of nonsense that was going on at the time.
Yes, definitely.
So I don't know if you've heard of this guy, Will, Sir Thomas Edison. Sir Thomas Edison was another who firmly believed in the prerogative powers of James I. And I know I keep saying that, but it's more so they kind of ignored the abuse of the prerogative powers. They were happy to just support all his policies, is what I was trying to get across in this slide.
Yes.
So he was an advocate for centralized authority and one who served the best interests of the state. Edison was heavily aligned with the rules of equity as High Chancellor, he presided over the interests of the Court of Chancery, which was meant to be a just court, but didn't involve trial by jury. Isn't that mad to think?
Yes.
You know, calling yourself a court of equity. So he
Yes,
clashed
I'll talk about that in a minute. Carry
yeah.
on for the moment, and because there's some interesting stuff about equity. But yeah, carry on. Sorry.
He clashed with Edward Coke during the famous Earl of Oxford case. The case could have been seen as an effort maybe to extend the prerogative while claiming power to overrule common law and suppress the idea that the judiciary should be independent from the influence of the king. It could be argued that Edward Coke became a target for those that supported the king's prerogative power. Coke appeared to be the only person brave enough to challenge the king's authority, and his outspoken nature was seen as a threat to all involved. So this kind of undermines Edward Coke. It weakened common law, meaning the Court of Chancery could overturn decisions made in common law courts. So this guy was kind of anything that was adjudged in a common law court. It was seen that the Court of Chancery could serve an injunction to basically annul that judgment.
Yes, absolutely. And this is where the beginnings of the Chancery and the Court of Equity were starting to come into play, which a lot of people now are getting confused and thinking that this was sort of like a better form of law simply because they labeled it equity. Right.
Yeah.
But what people are not understanding is that common law in its full form was the perfect form of equity itself.
Yes.
It was equity itself, as long as the the trial by jury was elevated in its full form and kept there in its full authority to judge the justice of the law as well, etc. Then the common law was performing the job of equity. It was a fully equitable system. So there was a little bit of well, could you say that was a bit of trickery going on there to form another kind of law over the top that was labeled equity to make it sound as though no, the common law wasn't really the thing. We've created a system of law here that is real equity. That's really suspicious.
I think I agree with what you're thinking, Will. I think it's just another kind of ploy to undermine the real understanding and meaning of common law and trial by jury in courts. Who would
I think so. It was
the real
capturing, capturing real common law and the mechanisms of common law, essentially. Yes, absolutely.
Because what's interesting with this, what I found, I didn't put it into the slides, but there was actually a spin-off of this court that was seen as a smaller, cheaper version of the Court of Chancery for poor people who couldn't afford. So it was like, hang on a minute, you're talking about equity, but are there different levels of equity? Do we need money to have this level of equity? And this cheaper version of equity isn't quite equity. It's just nonsense, isn't it?
That's total contradiction. Yes, amazing.
It obviously operated without trial by jury.
Yeah, these people they didn't like the powers of the king in one sense when it didn't suit them, but when it did suit them, they were absolutely prepared to dive in there. So because they liked that centralized control.
Yeah.
Right. So where centralized controls suited you, then they were only too happy to support the king being autocratic, and they're just not getting it and not being honest. And
I think also, we've looked at a few cases where people were trying to put checks on the king, but I suppose this was another workaround. Introducing these courts with like the Lord High Chancellor, who obviously supported everything, the best interests of the king. It was a way of saying, well, these decisions, this agenda is still being pushed, not directly by the king, although he's in control of these courts, but through people who he's employed to do that for him.
Yes, Absolutely, yeah. Centralizing the king's power around him for the purposes of those that might be just like hanging about near the
Yeah.
king.
So the
They want
king
that
can
power.
basically sit in the background and say, well, I haven't made this judgment.
Yeah, interesting.
We did touch on the Earl of Oxford case. This case produced a landmark decision that established the principle that equity should prevail over common law in cases of conflict. It was a land dispute that was initially heard in a common law court under Edward Coke, and an appeal to that judgment was taken to the Court of Chancery. Sir Thomas Edison, who presided, issued an injunction to prevent the enforcement of Cook's judgments. James I eventually intervened with the help and advice of his Attorney General, Francis Bacon, who was another statist. They both agreed with Edgerton's judgment, and the decision was upheld and became precedent to follow in all future cases. So I think this is kind of like, you can see Cook's approach and how it's going to threaten that system to try and kind of undermine him, but not be seen to just remove him and jail him or whatever it is. Try and do it in such a way where, you know, they can get round it and not be seen as like just basically trying to silence Cook or remove him in such a way.
Yeah. Yes, color it with a bit of PR.
Yeah, 100%.
Create some good optics. Yes, interesting. So that was a bad thing. That was not good.
Yeah, it wasn't good at all. It was kind of, I suppose, with the case of Proclamations and the other cases, the one in 1607 Prohibitions, this was kind of a defense for them in a sense to try and combat various judgments that had been made. But to be honest, Will, these judgments weren't even followed. There's cases after the case of Proclamations and the case of Prohibitions where James I has just completely ignored that.
It's just, yeah, absolutely. As he sees fit, I know.
So this was another, this guy, Francis Bacon, started as the Attorney General. But it's funny because he was actually, that James I went to Francis Bacon to discuss this, and he was about to step into the shoes of the Lord High Chancellor. So how is he going to rule? What decision is he going to make? He's already quite a big rival to Cook. So yeah, I just found that like he was kind of, you know, feathering his own nest because he knew he was about to step in the shoes of the High Chancellor.
That position.
Yeah. So Francis Bacon was a strong supporter of the monarchy and believed that in the importance of a centralized authority to maintain order and stability. He favoured a system of governance that allowed James I to use his prerogative at his own discretion and often unchecked, implying that the king could act without many of the safeguards that would typically limit the use of executive force. Bacon supported courts that operated outside of common law, meaning authentic common law trial by jury was bypassed to enforce the king's will and maintain state control. So we've mentioned before, Star Chamber, the Court of High Commission, Court of Chancery were all prerogative courts. Who presided over these courts? People like the Lord Chancellor. Prerogative courts played a significant role in the exercise of royal authority, often bypassing traditional legal and constitutional safeguards. It is a historical fact that Francis Bacon was found guilty of taking bribes to influence verdicts favourable to a select few, which undermined the rule of law and the notion that all are equal under the law.
So we've got the most inappropriate people rising in positions of power. Yeah, no, he's pure collectivist, this guy, isn't he?
Oh yeah, 100%.
We absolutely must take control over the people and issue diktats from the center because the people can't govern themselves. You know, that's the essence of it, isn't it? Pure collectivist.
The sense of morality, well, as a man within this system, wasn't really up there for me.
Yes, I mean that's where it becomes awkward because, you know, you could say and many collectivists do, of course, claim that their collectivist ideas come from a good place, come from a moral place, which is that, we must rule from the center because, we are in a better position to understand how others should live, right? Which is the ultimate sort of notion of taking your choices away because actually you are your own worst enemy, and the funny thing is that if the people are not conscious, then they're kind of right. That's the problem, right? So this is where it's important that the people take responsibility for themselves to show and to demonstrate that they can be their own governors, that they can govern themselves, because otherwise you could almost say that a collectivist, you're almost giving them the excuse to step into that void that you've left to then govern from the center. They're almost kind of making the right argument that actually you're not governing yourselves, you're not taking responsibility for yourselves, therefore I have every right to step in and take your choices away of your own self-governance. I'm not saying that that is right, but on the other hand, if the people allow for that to happen and are not stepping up for that, then that's what gives collectivists that kind of sense of authority to do so, and that's the problem.
Do you think, Will, that's basically where we've been, even from these times to where we are now? We're still in that same position where, are we capable of doing that at the moment?
Well, this is the point. That's the ultimate question that you're asking, is that, if the people themselves don't prove to themselves and to others that they can take that responsibility and become trustworthy, then, they haven't really got an excuse to whinge and whine at a central government. Because they're not on the moral high ground, right? And we've got the same thing going on back here, and all through history, really. And we've got exactly the same problem right now as well. You can't get yourself as a people onto the moral high ground unless you step up and take that responsibility and become trustworthy and care enough about true law and what right behavior is, what your rights come from, and question the authority of government and say, no, we want to be governing our society through trial by jury because, it's all about justice, and through conscience, and we understand what morality is. You don't get to do that unless you take that responsibility. So that's the issue, is that a centralized system will take control if the people themselves don't step up and take that responsibility. That's really what it's all about, ultimately.
Because I also think that our default seems to be, if we see injustice or we see immoral behavior or something going on we don't agree with, that the government needs to step in and do something about that for us.
Right, which is immediate outsourcing. Absolutely. Because the whole point about the constitutional law is that the people are the government themselves. The people are the police, and the police are the people. That's where the whole sort of citizens arrest concept comes from. And the Peel's 9 principles of policing, which I've talked about in the training of the police. It's all infused in there. The constitutional principles that the people are supposed to be the government. But are the people actually stepping up and doing that? Well, no, they haven't for generations. So therefore, what happens is that incrementally over time, the government morphs into this kind of slightly rotten form, which is autocratic and centralized control. And
I suppose it's the belief in authority as well, isn't it? It's kind of like bowing down. Like, we're not capable of doing that. When people are looking at the news or they're watching the telly and all that, and it's like, oh, there needs to be a law for that.
Oh yes, that's it.
It's like our answer is, create another law to deal with that.
And so that's immediate outsourcing. It's basically you not policing yourself, not negotiating with the individual that you need to deal with, not taking that responsibility yourself. It's basically saying, no, there must be a way for government to handle that and deal with it. So
the conclusion for me is that we're trying to minimize that. Shouldn't we be trying to minimize legislation and that kind of stuff? Shouldn't it be a lot smaller than what it is because we do
Yep.
take responsibility for right behavior.
So that's one of the dynamics that you're underlying there, is that impulse that we have of saying government needs to deal with that. There needs to be a law against that. That is playing into one of the dynamics that then creates more legislation from the center and giving power to government to, and not only power, but you're actually creating an expectation of government then to step in and take control. Government can turn around and then say, well, you just keep giving us this expectation to do the things you want us to do, so we just do it. And yet, on the other hand, you're not wanting us to do it. Well, which is it, guys? Because we can't, right? So that's the problem. Those are the dynamics that are in play here. And we're seeing it in the 17th century, and we see it now. Yes.
And that's fundamentally collectivist, isn't it? That's us slipping into that, you know, away from being an individualist into that collectivist mind state.
Yes, the individualist is being your own king, being your own king of your kingdom of one, essentially, your own government.
Sovereign, basically.
Being sovereign, yeah. The collectivism has two expressions. One is an out of control tyrant who likes to take control of others, and thinks that he has the brain and the capacity and the smartness to be able to do it, which he might in some ways. But the other expression of collectivism is absolutely submitting to that and saying, no, I can't do this. I just have to submit to you, to the greatness of you, because you are the experts. And those are the two expressions of collectivism, and neither one of those is right and is natural either.
That's actually quite dangerous, isn't it?
Completely, yeah.
Yeah.
Yeah, it leads humanity into a very dangerous place, and it has done. Look at where it's going here, and look at where we're going now. Absolutely.
Yeah. So this slide was about trying to give my own perspective on what these people might have been thinking surrounding some of these decisions that had been made, especially when it involved Cook.
Yes.
So from James I's point of view, Edward Cook poses a threat to his authority over legal and political matters. By siding with Egerton, he can assert his royal authority over legal matters. He can also maintain control over the judiciary, as the Court of Chancery is a prerogative court which is directly influenced by the Crown. The king knows he is better placed to control the outcomes of important cases if he rules in favour of Egerton. He can also take Cook down a notch by challenging the notion that the king is subject to the law. So from Sir Thomas Egerton's point, Egerton is loyal to the king and supports the royal prerogative, a firm believer in centralised authority in matters of governance. He is Lord Chancellor and controls the affairs of the Court of Chancery, which has come into direct conflict with the common law courts and Edward Cook. Egerton also knows with the intervention of the king, he could undermine common law and the common law courts dealing with any threat or influence posed by Cook.
Yep.
Bacon is also a statist who believes in centralised power and the royal prerogative. He has a long-lasting rivalry with Edward Cook. He is also about to step into the shoes of Sir Thomas Egerton as Lord High Chancellor. Bacon is currently Attorney General and legal advisor to the king. He knows that James is going to ask for advice, placing himself in the perfect position to control the outcome that best serves his own interests as future High Chancellor. Bacon can also get one over on his rival, Edward Cook.
Absolutely. Yes.
So there's a lot of personal dynamics as well. You know, it's
no, totally.
I can't do that. You know, that's a breach of the rule of law. It's like, how can I get one over on Edward Cook? You know,
it's a real soap opera as well, isn't it, going on?
It is. And funnily enough, I think I mentioned it to you when I was doing some of this research. They actually competed for the hand of the same woman. It's weird the way it worked out, because Francis Bacon was trying to orchestrate Cook's downfall, and Cook was kind of trying to orchestrate Bacon's downfall. James I He's been checked a little bit, but how can he get round that? Yeah, he can put his puppets into positions where they can do his bidding, basically. And
Yeah,
they're obviously looking out for them their own. They support that, to be fair. They're statists, they're
yeah,
collectivists. They
totally.
believe in centralized power and stuff. So it's kind of a win-win-win as far as they're concerned. And
Definitely.
the kind of defense is minimal. There wasn't really many people outside of Edward Cook who was actually trying to make any sort of change.
No, it's yeah, he was pretty alone, wasn't he, in that regard.
This is what we were talking about a bit earlier, the corruption and bribery charges of Francis Bacon. So Edward Cook brought these charges of corruption and bribery against Francis Bacon. He also played a part in the proceedings which led to Bacon's impeachment and eventual imprisonment. It is probable that Cook wanted to highlight the corruption of Bacon as well as the Court of Chancery. Bacon was fined 40,000, I don't know, 40,000 what? I don't know what that was. Probably a substantial amount of money of the time,
Hell of a lot of money, isn't it? Yeah, yeah.
which was overturned by James I. He was also pardoned and released from prison after spending only 2 days in the Tower of London. This is more evidence of the abuses of power James I exercised to make sure he stayed in control of legal and political affairs to best serve his own interests, fiercely defending his loyal supporters even when they were clearly guilty of immoral acts against the people and guilty of breaching the rule of law. It's the whole standards, isn't it? It's just a mess.
Yes.
People are being found guilty of taking bribes and gifts from people to.
In the big scheme of things, this is setting the country up for a bit of a revolution,
Yes,
which
definitely.
is, funnily enough, what's later starts to happen. It's
Like Charles I and that, it starts getting really messy, doesn't it? Because of
really nasty.
the remnants of what James I was doing.
We've got the stakes too high now at this point. Yeah, exactly as you've said. Too much authority on one side, immorality, lack of justice, and it's just setting up the nation for a major, serious problem, catastrophe. Yeah, it's really all about making sure that you don't allow things to get out of control beyond a certain point. Everybody needs to exercise vigilance all the time. And once you start going off track incrementally, you've got to bring it back pretty damn quickly. Because if it goes beyond a certain point, you're going to get this massive swing because everybody thinks the counterbalance has got to be the opposing power of the two. Yeah. And this is what we're leading up to, isn't it? You can see it going wrong. You can see the seeds of destruction coming about in this.
So, well, just to get your perspective on something that I was thinking when I was doing these slides is, we're talking about checks and balances and we're talking about constitutional law and the Magna Carta. At this time, who were James's peers? Who was meant to be putting that check in place? Like if we were talking about a common law court and hearing what the king had been up to, a modern day, Runnymede, who would be imposing that at this time?
Actually, I'd need to check on the detail of this at the time of James I. But what was the situation of the upper house? Because of course the upper house really was what became the lords. They were the barons essentially. It's the hereditary peers.
Yeah.
So actually, what was their situation at the time of James I? Actually, I should know that, and I don't, and I suspect it probably was somewhere in between what it was and what it was recently.
I'm not sure there's anything that well documented, to be honest, Will.
No.
Because
No, well, you've done more of a dig than I have on this, so that might be an interesting thing to check. I mean, I'm looking at some stuff at the moment to do with, I think I mentioned it to you because there was a sort of a crop of Germans in the 19th century, in the 1800s, that were looking at the the English rule of law. They were taking almost more of an interest in the English rule of law and the history of the Constitution than people in this country at the time.
Yeah.
Geneist being one in particular. So I'm looking at that now, but I'm not very far into it, if at all, really. But I've just sort of dipped into a few quotations here and there. So that might shed light on it, actually. But it's interesting. And so to get a sense of what the peers would have been at the time of James the First, that would be an interesting thing to check into. So I'll see what I can find on that. But that was meant to be the hereditary peers, and the reason for that, of course, was that they were, kind of a similar standing in terms of they weren't professionals appointed to a short-term position. Yeah, the point of the hereditary peers is they were a little bit removed from that day-to-day political stuff that was going on. It hadn't properly developed in Parliament at that stage. It wasn't till the early to mid 1700s that you started to get that sort of party political system in place. Obviously, following the massive upheaval and the change within Parliament. So you didn't have that going on now during the time of James the First. But nevertheless, there would have been hereditary peers who would have been the peers of the monarch, and they were the ones that should have stepped in at this point to, who would have been communicating with Edward Coke, for example, and then bringing him to trial, like would have happened in 1215. But they were way off. They weren't really understanding that that's what should have been done. I think. I don't know. I have to look at it more.
Might be worth looking into that with Charles the First as well when we go into
Charles the First. Yeah, totally.
The next video. I might,
because they dealt with that very wrongly. Yeah, exactly.
What I can dig up. There was basically an inquiry into Edward Coke.
Yeah.
And I think it was around when he was dismissed from the bench. So what happened was, it was before the bribery charges on Bacon. It was another way, I think, of getting rid of Coke. So there was an inquiry into his conduct, and Francis Bacon and Sir Thomas Edison played a role. It was like 1616.
Okay.
So what happened was, because of his continual outspoken views on certain political and legal issues, he found himself under investigation, like for conduct. So the people, like part of the Privy Council and Sir Thomas Edison and Francis Bacon, they influenced that investigation, and it ended in his dismissal. He was dismissed from the bench.
Wow, interesting.
After Bacon's bribery charges and his very brief imprisonment, what happened was Edward Coke, and this is what this slide is about, he spent on two separate occasions during the years of 1621 and 1622. The reasons are many: his continual outbursts against the king and his royal prerogative, his defence of common law against the injustices and unlawful use of prerogative courts, his actions against Bacon, which we've just touched on.
Yeah.
So Thomas Edison, Richard Bancroft, another guy in the church, at the beginning, he was challenging the ecclesiastical courts, the High Court of Justice. He was just put in prison. I think the king just ordered his imprisonment. And when he was tried, I think he was tried a couple of times. There wasn't really any charges. There was nothing they could charge him with.
Yeah.
But he spent 6 months in jail the first time and around 9 months the second time. So he spent quite a lot of time in prison for, saying these kind of things, taking these kinds of actions. But funnily enough, you won't see the king using his prerogative to pardon Coke or to get him out of jail. It was kind of like, well, look, you're in jail. You need to ponder over your thoughts and your future conduct, kind of thing. If you continue to speak out, this is what you're going to get. and maybe worse. A conclusion to what we've discussed. Although the lines were often blurred and the understanding wasn't quite there regarding common law, natural justice, natural rights, trial by jury, jury independence, equity, individualism, dangers of collectivism, natural law, morality, Cook's actions can be seen as steps in the right direction. Edward Cook was an early example of somebody who was trying to reverse the many wrongs that were taking place during this time. Sadly, there are many contradictions that suggest the full comprehension of what an equitable system was supposed to look like and how it was meant to work was fundamentally missing, even though constitutional law was present. Magna Carta 1215. The people were often forgotten amongst the sea of arguments regarding prerogative, ecclesiastical, and parliamentary powers. This also appeared to be the case when it came to fighting for judicial independence for the courts. It didn't go that step further, lacking the belief and commitment to authentic common law trial by jury and jury independence.
Yeah. Yeah, no, good summary. Definitely. Interesting, isn't it?
The whole pendulum shifting from monarchy to parliament was the distraction.
Right. Not dealing with it correctly. Yeah. Yeah, absolutely. Interesting. No, that's really good. That's a really good piece of research, Damien. And fascinating sort of insights into what was going on. And by doing this, it's an interesting exercise. You know, we start to build up a broader picture of where things were going, what the trajectory was, and you know, and as I said at the beginning, you know, I don't think many people do this with an understanding of constitutional law at the same time as looking at the events of history and actually bringing those together. So nice one, good.
Yeah, I think it was easier knowing when I had a basic understanding of what that system looked like and how it was meant to operate. When you look at history, it's really easy to observe where it's going wrong.
Yes, hindsight is nice, isn't it?
Yeah, I think one of the biggest things was to show that, you know, these kind of arguments have been going on since the year dot. Repetitive arguments about, you know, who controls what, how it's meant to work, you know, who needs to abide by the rule of law, who's above it, you know, the whole divine right of kings is never going to work alongside constitutional law.
No, and it just shows the imperfections of man, you know, and how easily we can fall into traps of misunderstanding, which is why actually, you know, having a clear understanding of the Constitution, having a clear understanding of what an ideology of individual rights, individualism is, what does it look like? It's not really that difficult. It's not really that complex once you immerse yourself in it. But, you know, the people need to do that all the time. They need to be vigilant all the time. Otherwise, you're just going to let things drift off. And you do it when it's small, when the threats are small. You don't do it when the threats are large because, well, you might have to, but at that point, things are going to be a bit tricky. The stakes are much higher, you know. But you've got to do it when, you know, all the time, and be vigilant for that reason, so that things don't wave off track too much. This is all part of human evolution, ultimately, isn't it? You know.
Yeah.
It is about the raising of consciousness, and raising of consciousness means really just simply a raising of awareness of our own sense of what right and wrong behavior is, morality, being clear about what rights are, which comes from right and wrong behavior, and therefore what justice is, and how that should be administered, and you know. But yeah, really interesting.
I think also, Will, like when you were touching on, you know, there's a lot of emphasis on the royal prerogative. It is just to reiterate that should be there.
It should be there, yeah.
But it has to fall in line with constitutional law, with the rule of law.
Yeah.
You know. So
Totally right.
that was, I'm glad you brought that up because, you know, it's important for people
Yes,
to
no ambiguity there. That you know, the monarch is the head of state. it is their responsibility. That works both ways. It's not power. It's not about power, but it is about the ultimate responsibility. And of course, now we don't have that sense of it at all, and I was involved in the writing of a letter to the Duke of Norfolk at the point of the coronation of the king, reminding him that actually you do have these responsibilities, by the way, and you are supposed to exercise them.
Yeah.
So but that sense of it is just not there at all, and quite deliberately removed. Yeah.
Because I like, even within the freedom movement over the last, I'd say, like, at least the last couple of years, with the head of state like wanting to get rid of the monarchy, wanting to get rid of the head of state.
Very dangerous.
And they want it to be a republic, and that's going to be so much better. But the funny thing is, when we get into Charles I, and even further when we get into Cromwell, when we were a republic,
disaster.
It was absolutely disastrous.
Absolute disaster. Yeah, so anyone who's got this idea, this notion that a republic is necessarily any better than a monarchy, I would say it's the other way around, actually, probably.
Yeah.
I mean, the first instance is if you could say that if trial by jury is in full operation authentically, with full jury independence, does it ultimately matter whether you have a president or a king? Probably not so much in that situation. But actually, ultimately, I would say that the long-term offices that we have in this country, and as long as you understand what a monarch really looks like in the context of a limited monarchy, and that they are placed under the law themselves, then I would favour a monarchy of the type that we had, of course, in the late Saxon times. Absolutely no question about it. The long-term offices are really good. They're important because it removes people from that day-to-day political what we have now, which is this crazy kind of party political system. You don't want the long-term offices, which are meant to be the checks and balances, also mired in those kind of short-term interests. People, backhanders, people being paid off, behind the scenes. You don't want that kind of stuff going on. So the whole point about a long-term office is that they're not quite so easily bribed. They've already, it's not privilege as such, but they've just got these long-term, their station, if you like. That is their station. They're not going to be worried so much about, they've got long-term interests of the realm. Yeah, that's what the lords were supposed to be about, really. And then the king as well. So, yeah.
Good stuff, Will.
Nice.
It was really good to chat.
No, thank you for that.
Part in this as well. I appreciate it.
Fascinating. Well, me too. I mean, you've done all the historical research, and I knew some of that, but nothing like all of that detail. So it's really interesting to do that and to put some constitutional law stuff around it and to see how that's going. So you've got another one, haven't you, as well? So we'll keep going.
Yeah, but this is going to probably go on up to the Glorious Revolution. This is going to tail off into Charles I, into Cromwell, into the Restoration, Charles II, into James II, into William of Orange and the Glorious Revolution. So it's going to be really interesting. I think it'll be good. It'll be a good little series, and it'll get people to look at it themselves, how it relates, what our constitutional law, how it's evolved, how is it, what did it look like in the 17th century? What did it look like?
It's really putting the ultimate story behind it, because actually history, if it's just taught as a series of events, and I know historians would say, well, it is a story anyway. Well, yes, but actually if you put matters of justice behind it as well, and where the country was going morally, now you're putting the ultimate kind of story behind it, and so it really starts to become quite profound and important, and something that we can actually learn from, or not.
We can look at history and we can talk about morality. We can talk about
interjecting that in with it is really powerful, isn't it? So it's been a great pleasure to join in and be part of that. So I've enjoyed that, and we'll enjoy the rest of them, certainly. So
brilliant.
Good. you.